one of my favorite topics today about contract and how do we redress sometimes, although people enter into contracts, they still don't feel that, I've got the remedies that I wanted. I have to go through a lot of years of litigation. So this session is about how to make the contract itself strong, how to ensure that your contract is good enough, it is it is strong, it gives you some amount of remedies which are inbuilt within the contract, so that any time in litigation is not spent and the court is able to easily interpret the contract through the remedies which are recorded inside. So we'll be looking at a little overview of the contract. Then there are few clauses which we will examine more in detail today, like indemnity, risk purchase, bank guarantees, representations, warranties, refund, repairs, insurance, damages. And of course, we'll conclude with the best practices and procedural safeguards that are a must for every contract that you enter into. Okay, so roughly, does anybody have any idea how many transactions does one enter into during the day? When I talk about a contract, every time you get into a transaction, there is an agreement which you enter into. So does anybody have any idea? Like on an average, suppose when you start your day, I assume some of us are students also here, and I always like to learn. I still call myself a student. So when I start my day, I get up, maybe I use a product which is made by somebody else. It has reached me through somebody else. It was manufactured by somebody else. Maybe somebody else acted in the advertisement to get it to me. So how many transactions would I enter into? Maybe in a simple activity of, say, brushing of a teeth. So it's not, maybe I'm not entering into each of the transaction myself, but what all has happened around it. Somebody prepared the toothpaste. So there must be a raw material manufacturer. Then there must be somebody who had produced the product. Then somebody who packaged it. Somebody who must have labeled it. Somebody who must have packed it, got it to a particular, from the factory to a retailer outlet. Or, it was on some platform. From the platform, it was purchased. Then there was a delivery partner. And then it came to you, and then ultimately you use it. So the world is becoming a very globally and a very close-knit village now. It's very easy for us to get things from anywhere. It's very possible for us to look at something which was there in some other part of the world. It was not so easy, I think, even a decade ago. So now the amount of transactions, the amount of agreements which any entity is entering into is like growing. It's growing by leaps and bounds. And the number of transactions that we enter into on a regular basis, we want all of them to benefit us. We don't want any of them to, become a liability for us. I don't want something which is, like it's hanging on my neck. I really don't know what I committed to them. So when we look at so many transactions, it's very important that we spell out our expectations very clearly in the agreements that are entered into by the parties. The agreement or the contract that you're looking at, it should have enough safeguards. It should have enough remedies to say that if something was not working out, I have some remedy. I can do something. It's not just an empty sheet of paper that I just signed randomly without any kind of commitment to it. And of course, it needs to have some formalities for execution also for it to be enforceable. It cannot be that I just sit and write something and it becomes an enforceable thing. Then there are ways and means to do things. So PLEA has had, I think, some very good sessions in the past also on how an agreement, what are the essential elements of a contract and other things. But, just to ensure that we're just doing a little brush up of an overview before we deep dive into the topic. So when we talk about expectations, now all of us are watching IPL. Now, when you look at any player who's playing IPL, and of course it was preceded by the Women Premier League, which I also followed very, very closely because I love women cricket. So when you look at a player who's coming in, who's playing, just look at his t-shirt. Wow, how many logos are there on the t-shirt? How many people are sponsoring that? So now if there must be a contract behind it. There is a contract which every player enters into. And of course, there are cases when a player does not behave, he's fined and other things. So, there are consequences which are listed. Similarly, if you look at the back-end contracts, the t-shirt is, it's printed, it is made, somebody has to give the logo on time so that it can be printed on the t-shirt. The color combinations are designed. So there are many things happening at the back end as well whenever we see something big. So as we progress as lawyers, we should train our eyes to realize that there are transactions, agreements, contracts behind everything. It's not, we don't live in a world anymore where there is a barter system or, I give you something, you give me something back. We don't exchange in things. We exchange in rights. We talk about obligations. We talk about duties. So when we are looking at any kind of, event, if you look at, or if you look at any product which you see in your hand today, there are things behind it. So it'll be your job, and it is a job of most of the lawyers to ensure that whenever they're drafting an agreement, expectations of each party are put in very clearly. It's very important for us. If you look at, I've purposely chosen this image so that, what meets the eye is very less. It's our duty as lawyers that we understand the background completely when we look at a contract. We need to deep dive. We need to understand what is exactly the purpose of this contract. What is it that you're looking at? Now, somebody is selling maybe a furniture, somebody has a furniture shop. They need somebody to do the designing of furniture. So when they do the designing of furniture, so, he will expect that it is original. He'll expect that, it's not taken in from some other shop, from somebody else's creativity. He will expect that it is given in a timely manner, so that he has to make the furniture basis the design and then give it to somebody else. So sit with your client and always understand what is the background of this whole transaction. What is it that we need to achieve through this whole thing? It's not that we just need to finish a 4-pager or a 5-pager agreement and get it signed and get it done with. It's not going to help. We need to understand the background completely. We need to understand what kind of obligations, what kind of rights, what kind of duties we need. Another aspect is every agreement is very unique in itself. So while, we will be talking henceforth in the, in the few minutes which come forth, that what are the standard clauses which are generally there in the agreement and which will help us to address any kind of, distress that we are likely to face because of the contract. Each agreement is unique. Each transaction is unique. Because even if we look at a transaction, say, of purchasing of a garment, or, maybe somebody is just going and purchasing something from somewhere. When you purchase it through a street shop or when you purchase it through a branded outlet, there is a difference. There is a difference in terms of the quality. There might be a difference in terms of what you expect from the product. So when you take it from a big shop, maybe you will expect that it is good. Maybe you will expect that, oh, it should last. It is that color is not going to leave soon. But when you take it from somebody else, you're like, all right, I've got a good deal. Let's see how long it lasts. So we are also aware of some specific, and there is always a perspective to every agreement, every transaction that we enter into. So it's very important that we deep dive, we understand what is happening here, and try, instead of just getting into the legalities, first get the overall background as a whole. What is going to be happening in this transaction? And then we can move forward to a drafting of the contract and preparation of the contract. So when we look at contracts these days, it's very important for us to understand that some of them are on a back-to-back basis. When I say back-to-back basis, what I mean is that today we are not looking at consumer rights really. We're looking at customers. We are looking at some specific perspective of a contract. But every time there is a relationship that I get the product from somebody and I have to take it forward to somebody else. So suppose there is a person who has to deliver the products. He needs to get it on time so that he can give it to his customer on time. So it's, whatever my customer wants, I'm going to put the same deadline on the previous chain, or maybe a day earlier so that I have some time with me. So this whole thing of back-to-back basis is very important to understand if there is such a case, and if you're not directly dealing with the consumers. Then specific requirements need to be understood in every contract. You need to ensure that there is a thoughtful negotiation which is done in every case. And we just don't, bang our tables, and we just don't shout, because just a loud voice is not going to help us anywhere. It needs to make sense what we are talking about. What is the negotiation? What is the core purpose of the contract for which we are entering into, and what you want to achieve through the contract? Then there are, of course, certain remedies which are very important, in every contract to ensure that there is some redressal mechanism available to you. Now, these remedies, we are going to look at it slowly, one by one. There are about 6 or 7 remedies specifically we have thought through, which my experience has shown me, which we can use. Now, what are some customer requirements if, you were a customer? Can somebody tell me what would you expect as a customer in a document?
Being a customer, I'll expect that I should get a good quality products, good services, and what the amount I paid should be, whatever I paid I should get back,
Yeah, there should be value for money.
Yes.
We are all Indian customers ultimately. Negotiation is our birthright. So whatever we pay, it should be like proportionate to the services that you get. Yes, that's a very good point. Thank you, Tina. So yes, you're absolutely right. As a customer, I have some requirements. I want these things, the whole purpose of me coming to the service provider or the vendor is to ensure I get these things. So this is what we understand as customers. Now put your customer hat aside. Now what happens is, we have some kind of, one second, what happened to my hat? So now when we put on our lawyer's hat, a lot of times we will see typical customer oriented clauses in your documents, which will be something like a most favored customer clause. You will see a right to withholding payment clause. You will say that my records are binding on you. You will say that I want to put a penalty or I want to put a damage on you. Now, when I asked you what are your customer oriented requirements, none of us spoke about any of these things. But these days, a lot of documents have these kind of clauses. A most favored customer typically means that I want a price which is lesser than the price that you're offering to anybody else in the market. So suppose you're offering me 10 rupees, you should not sell your product to anybody else at 15, at less than 10 rupees, at 8 rupees, say. So this is a most favored customer clause. And these kind of clauses, or the second clause to say a right of withholding payment. Like I want to have a right of withholding your payment till the time you don't give me the money. Yes, this sometimes we do in practice. We do say that, I remember when I was a child, my mother would never give the istri wala the money till the time, the all the saris or everything was not given properly to us. So people do these kind of things. Then records. This is very typical that whatever I have maintained in terms of records, like, if I have said that you have delivered me the products for 30 days, if I'm taking something from you daily, if I've given to you, if I say 25 days and it's 25 days. So this is kind of, an aggressive behavior as a customer sometimes, which some parties do enjoy. And some parties do have the privilege in the market to, yes, demand these kind of services and demand these kind of clauses. But we will not be looking at these clauses today, but this is just for a background that, these clauses also come, and there is a way to look at each of these clauses and how to drive in loopholes from a vendor's perspective. Now, this is what the customer will, an aggressive customer or somebody, a powerful customer will really demand in each of his contract for themselves. Then what are the vendor requirements? Now, suppose I'm a service provider. Each of us have had both the roles at some point in time. So again, as a vendor, what we will expect is, I want my payments on time. I want a clear expectation that what is it that I'm required to give you? Because a lot of times it happens that, we are unable to understand what was the expectation from my side. And, and when there is a breach, then the parties will be like, oh, I understood something else. You never said that it is to be given in 2 business days. I thought, it was, or maybe 2 days. I thought it was 2 business days. And now I'm not working on this Saturday, Sunday. So this is a very clear kind of, a kind of misunderstanding which happens through the contracts. So all of these need to be limited. When we look at a vendor, he will expect that there are limitations, there are customizations, there are, if somebody is expecting some kind of customization or a modification, there is a limitation to it. Like suppose I'm a software provider and the client is expecting some kind of customizations, I would expect maybe maximum 1 or 2 rounds and not after that, because you cannot keep coming back to us again and again and say, okay, now you change this, because every time there is a customization, maybe the vendor is getting paid, maybe there is no provision in the contract. So all of this a vendor is going to think about when he looks at a contract. Now he will expect something like a wide disclaimer. He will expect a broad limitation of liability. Like you will see a lot of times we do so many online transactions. So just open any terms of use of any of these portals, and a lot of times the liability is limited, and naturally so, because the platform is just it's an online marketplace. It's not something which is, they are manufacturing or anything. So they are definitely not going to take any responsibility of the product which is being sold on the platform. Then sometimes people want various factors as force majeures as vendors. So, sometimes it's a debate. What can be a force majeure, what cannot be? Like a typical example is, say, fire. Now, fire, whether it's an external factor or no. A lot of times some customers refuse to believe that fire is a natural occurrence, because somebody has left a cigarette butt somewhere, somebody has left if it's a short circuit, somebody has done some kind of negligence for that fire to occur. But whereas any vendor will want to include fire as a force majeure. So every time, when you look at a contract specifically, there are always 2 perspectives to it. So the whole point of, showing these 2 clauses, showing these 2 sides was to understand that whenever we look at a contract, there are always 2 hats that people wear. And that's when, the contract negotiations take a very, very long time. Sometimes contract negotiations go on for few months. Sometimes they go on for years also. And still people are unable to conclude and execute the contract because parties are just not able to come to that consensus. So when we look at an agreement, a balance is something which is a solution sometimes. We really need to understand what are the rights, what are the obligations, and balance it with the core purpose of the agreement. So when we say that what can I include as a remedy or what can I get out of a contract? So the answer could also contain in what are you giving in the contract in the first place. If you are able to give something, then it's also possible to demand something. Balance balancing it out completely is going to be very, very important whenever you look at any kind of a contract negotiation, and when you're looking at a speedy contract negotiation. Because when you look at yourself as a contract lawyer, the job is of course always to ensure that the interests of your clients are appropriately safeguarded, and you educate, and we review the contract thoroughly. Whatever is onerous, those clauses are pointed out, discussed, debated thoroughly, consciously. It's a risk or it's an obligation which is agreed into. But at the same time, what is it that is being offered to the other side in return is very important. So now we look at some specific clauses which are always there in a document and which are very, very highly debated in all cases. So how to look at those contracts, how to look at those clauses. Let's understand those clauses. Indemnity is one of the clauses which is always there. You'll always find it in contracts. Every party wants to be indemnified of all kind of, losses, claims, damages, anything which you suffer from the other side. So indemnity, I think, as most of you would be aware, it's provided for under the Contracts Act. And what it typically says is that it's a promise by which the indemnifier or the person who's giving the indemnity, he promises to save the other from any kind of loss, which, that other person may suffer because of his conduct. Say, suppose I am entering into a contract with another party, XYZ. So I tell XYZ that, look, I am supposed to give this product to you and I am supposed to give these services to you. Suppose you have a problem. Suppose you suffer a claim from a third party because of what I did or because of the products that I gave you, then I will reimburse that loss. I will hold you harmless from that loss. Indemnity is something which is becoming very negotiated and very, very debated these days, because the scope of indemnity is getting wider and wider and wider. We are expecting indemnities in documents for intellectual property infringements. There are indemnities for breach of confidentiality obligations. There are indemnities for data privacy obligations. There are indemnities for breach of obligations. There are indemnities for non-compliance of laws and multiple other things. And a lot of times, there is a mindset which says that, okay, let me have a very broad indemnity so that I never suffer anything from this contract. But it's important to understand what is it that you're entering into also. Now, suppose you're looking at a contract wherein you're taking some software, you're taking a license, or, you're obtaining a software. It's a contract which gets a software license for an entire organization. Like, we all use software systems in our organizations. So we get a software. Now for that document, it makes a lot of sense to have an IPR infringement indemnity for us. It makes sense because I don't want to be sued by somebody else for using a copied material or using an infringing material. So that kind of indemnity will typically say that, A seller agrees to indemnify B in case the software provided by A is an infringing software or a software that contains any malware or a virus. Now, indemnity for malware or virus also is sometimes debated, because people say that, oh no, it was not in my hands. I just didn't know what happened. But yeah, we can always debate. We can always think about what is the relevant contract, what are the stakes of the parties, how much is the payment, what is the giveaway to the other side in the first place. And what will happen in this case is, if you get an indemnity in a clause in an agreement which is signed with the software vendor, tomorrow when you actually go for any litigation in case of a claim, you can use this indemnity clause. This will help. This will ensure that, anybody who's looking at the contract through the dispute resolution mechanism, suppose there's an arbitration or suppose there is a litigation provided, there are any courts who are going to look at it. So the court will also see, oh, there is an indemnity clause which is agreed amongst the parties. So the parties have decided that, yes, the vendor did decide that, yes, I will indemnify. So, unless until there are other issues, the indemnity clause is likely to help. But at the same time, we must remember that we should only look at relevant indemnity should be obtained and insisted upon. Because as much as we are zealous about safeguarding the rights as customers or as purchasers, we must ensure that, we are only insisting on relevant things, because the vendor is also going to have their own legal advisor who's going to advise them. Now, suppose you're looking at a contract wherein, you're taking some courier services from somebody, or some kind of, say, data analysis, or some services which have no element of any originality needed. So then why would you include an IPR infringement indemnity in that? You will look at an indemnity which will look at maybe timely delivery, which will look at some kind of, safe delivery or something like that. Safe material is used for packaging and relevant to the context. So that's why that understanding the perspective is very important. whenever we draft these important clauses in an agreement. So let's not look at, some kind of a clause which is just available somewhere and take it. It's important to apply ourselves to understand the context and then include a thoughtful indemnity there, because it's a powerful right. It's a right which we have under the contract. Now, here we would like to look at one of the cases. It happened. This was one of writ petitions. It was a batch of writ petitions rather before the Telangana High Court. Punjab National Bank, Bhimrao versus Punjab National Bank. So here what had happened was, I think most of us are aware that there are some kind of value services which are obtained from which a bank needs. So they need to value the assets of the borrowers, and it's a very critical services for a bank. It's not something wherein, I can just do away with, or I can go and get it done with through a non-expert person. So here the bank came up with for all the existing valuers, they came up with a detailed letter of indemnity, and they expected all the valuers to sign that letter of indemnity. And they said that you need to indemnify us because you all are experts in this field. So most of the valuers, they went and they challenged it before the High Court, because it was a state entity, Article 12 was applicable. And what the High Court said in this case was, it is clear that the amount disbursed by the banks as a part of their lending activity, it depends on the valuation of the security that is deposited. The valuation is absolutely, it's a sine qua non. So that means it's very important. And bank, if the borrower fails to return, then the bank is not going to have any remedy. So to ensure that everything is done properly, we need that kind of an indemnity. And the court said that the bank is justified in including an indemnity of this nature. It's not something that, you can do away with. So the bank told the valuers that the bank needs this indemnity. If you do not want to give this indemnity, you please don't sign the agreement. You please move out if you're not interested in this. But it's an important clause, and the validity of the inclusion of this clause was upheld by the court. So while indemnity is important, we must remember that when we are looking at an indemnity, it should be relevant. It should be important to the core purpose of the contract. It can also be sometimes there can be some limitations to suit the transaction and the parties. Like you may choose to limit some indemnities. You may choose to say that, all right, attorney fees are not committed. So a typical indemnity clause will have a obligation to, reimburse the attorney fees, to reimburse all kind of losses, the costs, expenses, and other things. So depending on the transaction, depending on the parties, you can always tailor-made the clause to see what is it that you can take the risk for and what is it that you don't want to agree. But what we should always remember is that there should be a conscious approach to the clause. It's not a clause which can be just lifted from one document and pasted into another document. It's a clause that's very alive. It's something which is going to be there. It's going to be, it's going to hang on the neck of the vendors for a while. So it's important that we commit to it in a thoughtful manner. And language is to be absolutely, it's a customized language, which you think as per the discussions and after understanding the perspective from the client, what is it that you're sure about that you can indemnify them for? So that's about indemnity. Let's move to the next clause. Now, this is risk purchase. The risk purchase typically means that in case, now, as we all saw that, some people work on very, very tight timelines in today's world. If there is, suppose you look at an event, and again, let's go back to some big event. Like suppose yesterday, today is Bihu, which is a new year. Yesterday, there was an advertisement in the newspapers everywhere that our own Prime Minister Narendra Modi ji is visiting Assam. And there was going to be a lot of Bihu dancers who are going to be attempting a Guinness Book of World Record. And there are going to be, I think there was a huge number. I'm sorry, I forgot the number really. But yeah, there were some thousands of dancers who were going to attempt to create a record on the occasion of Bihu. So this is a time-driven kind of an event. You cannot celebrate Bihu 1 week down the line. You cannot wait for it if it is happening. If the PM's visit is scheduled on a particular day, it's going to happen on that day itself. Now, if you look at the agreements which are going to be around this event, suppose somebody is going to provide costumes, somebody is going to come and do the makeup, somebody is going to maybe provide their accessories, there'll be a sound system, there'll be lightings, there will be chairs, there will be some kind of event management. Everything has to happen, and everything has to happen around that date. That date is very important. So what typically a risk purchase clause provides is that if I am unable to get the services from the vendor on a particular date or product still a particular, in a particular manner, or say I do not get it properly, I have the right to go and get it from the market. And when I do so, when I get it from the market, I have the right to be reimbursed for that from the vendor. Because originally there was a commitment, like suppose I gave a contract for the costumes to a particular person. And I said I wanted them by say 10th of April or 12th of April. Now, if I do not get it on 10th or 12th of April, If it is possible for me to get it from the market, I have a right to do so. And whatever is the differential cost, because obviously if you're getting it done on one of the last days, then you may have to pay some extra amount also, because you're getting it the last minute. So then that differential cost, I'm going to levy it on the vendor. So this is what it typically will say, that I don't have to suffer as a customer or as a purchaser, because my whole purpose of the contract is revolving around that event or around that day. I don't have the liberty to wait for a very long time. I don't have the liberty that you may have had your issues, but I can't wait. I need to do it on that point in time. So in these kind of cases, what is generally understood is that the purchaser can claim the difference between the contracted price and the market price, and he can also maybe claim some kind of delivery charges. He can claim, if I had to get the products from another location, then there'll be some flight charges. So there'll be some kind of charges which are associated. So risk purchase typically means that if I don't get the products from you, I get them in a defective manner, deficient manner, delayed manner, or it just doesn't suit whatever was committed by you. You promised A quality, you've given C minus quality. So I'm not going to wait. I will get it. So this kind of a clause really helps the customers and the purchasers sometimes, because as I said earlier, there is a back-to-back arrangement sometimes. I need to get it from you so that I can deliver it ahead. Now, if you don't give me, that person is going to anyways levy all those damages on me. So I'm going to again impose it back to you on a back-to-back basis. So risk purchase clause is becoming very, very important and crucial in these days. Again, this is example of a risk purchase clause that you would see sometimes in a contract. So how it is going to read is, say, notwithstanding anything to the contrary. So that means it's a clause which is supposed to be read in a notwithstanding manner. In the event of the failure of the seller to deliver the products agreed under this agreement, seller agrees to reimburse to the purchaser. So what all does the seller agree to reimburse in this case? Cost incurred by the purchaser to obtain goods from the market. So suppose I get the goods from the market. So what's the cost for it? I am entitled to a reimbursement for that. What are the costs for transition? So I spend some cost in the transition also, or like obtaining substitute services. They are not just available outside, my house. Somebody's not going to wait at my door that, oh, your vendor has breached your contract, here it is. There is a cost associated with that. Then whatever kind of fines or penalties or whatever interest. So this is a very broad clause. Again, this is a very important remedy which can be incorporated in a contract, which allows a customer that, okay, I can get it. And of course, the reimbursement will have to be obtained through litigation, but at least there is a right in the contract. Suppose you have no right in the document and all that you can do for breach is termination. So now you think whether that contract is really strong or no, or these kind of remedies do help. Because when I have the liberty, at least my work gets done, and I can always send a notice for any reimbursement. I can always send a notice for any kind of say, I want to claim this from you. Now, again, when we look at a risk purchase clause, it's from a vendor's perspective, it needs to be balanced. As I said earlier, that just demanding too many remedies and demanding too many things is not going to help, because the contract will never get concluded. Some appropriate limitations also can be incorporated. Now suppose we had a commitment to get now if you look at that event example that we saw of there's an event at Assam, and of course there will be somebody who's going to provide sweets also, because no Indian festival is complete without sweets. So there was some, I decide to take sweets from a particular restaurant. Now, if that restaurant does not give me the sweets, I cannot go to a restaurant which is operating at a much higher level and charging triple the amount at all points in time and getting it, and then ask a reimbursement at the same time. Because, as a vendor, I will say, actually, if I'm not able to give you, you take it from a vendor from the open market, from somebody who's operating at a similar level. So the vendor can also build in some kind of a cap in the clause to ensure that, his rights are protected. He ensures that, there is in case, the commitment is not met, the liability of reimbursement is not extraordinarily high. Then it's a conscious clause again, which needs to be determined considering the competition or the other competitors in the market. And enforcement or invocation of this clause, like when does this clause get kicked in? That is very important. It needs to be thought through by the parties before, and of course the lawyers also, when you include this clause in the document. Is it any breach, or is it only breach of delivery of products? Because, a contract, if you will see, it's a bundle of rights and obligations. You will have maybe, 30 different obligations to cover when you assign a contract. You will, apart from, there is a core obligation that I have to give you the product. Apart from that, there will be other obligations. I have to give you reports. I have to maybe, maintain your confidential information. Then there will be other commitments, like I have to maybe, submit some kind of data to you. on a regular basis. I have to do some testing at my end. I have to give those testing reports to you. Now, whether it's typically done that, if you see that there are some kind of tests which are done, then there is some kind of analysis which is done of the product. There is some kind of quality testing which is done. So does that breach entitle the customer to invoke this clause, or only non-delivery? Now, somebody cannot say that, okay, I have just not done the investigation report on time, or maybe I have done it, but I have not given the report to you. Sometimes all kind of, things go wrong when, not wrong maybe, but they get delayed. So suppose I'm supposed to submit a report to the other party on, say, 1st of every month. Instead of 1st, I sent it on 5th. Now, is that a breach? Can they just get the product from somebody else and ask me to reimburse? Because I did the testing, I'm in the process of making the product. So why should it entitle them? So the breach should be very clearly defined. Like here in this clause, if you see, it says, in the event of failure of seller to deliver the products. So we are looking at a failure of delivery only. We are not looking at a general breach. We are not looking at a general non-performance here. So this clause needs to be again defined very well, thought through appropriately to ensure that, the remedy is there in the contract, but it's in a balanced way so that the other party is also able to do it. After all, looking at the current state, it's our duty that our contracts are strong enough in themselves so that litigation is avoided as much as possible. Both the parties have really understood the contract and they meet it. Of course, if they commit to something which they can do, then the possibilities of breaches and litigation reduces. So even if they have committed something, they're not able to meet it, they know what they have to give. Mindsets are there. Some people litigate even if they know they're wrong, but at least the contract should be clear so that the time is minimized. Then another important clause that we can incorporate in a contract is for bank guarantee. This is something which is not always included. It's generally included for big projects, for something where there is a huge, when there are huge stakes involved. When suppose we look at something like an electricity board, MSEB or MPEB or any kind of these electricity boards, and they want to set up their own big plant. So when they want to set up a plant, everything becomes huge. It's not a simple product, or it's not a simple, the examples that we saw earlier. It's not something as simple as somebody getting up and purchasing a toothpaste or a toothbrush online and getting it for them. It's not that. It's huge. It's magnanimous. If we see any of these plants, they are like, the moment you look at it, you're like, oh God, this is so big. So when we look at big contracts, typically bank guarantee is always there. In tenders, you'll see in most of the tenders, RFQs, which are floated by the government bodies, they expect a bank guarantee. Cooperative societies are also huge when they are undertaking the whole renovation work for the whole society. Like if you see in Mumbai, in many metros these days, cooperative societies, they have like townships. So if it's a township contract, if it's big, so the purchaser is not going to be, he has many obligations, he has commitments. Like somebody who has won the tender, say L&T or, any of metro. If you look at the metro project these days, there is a timeline to it. So when a project of this sort is getting implemented, there is a head contractor, say L&T is there, Reliance is there. They will have their own vendors from whom they will expect a bank guarantee. Now, bank guarantee is a sure shot mechanism so that in case there is a breach and it's an unconditional bank guarantee, then the purchaser can just invoke that bank guarantee from the bank. There are clear legislations which say that a bank guarantee is it's an independent contract in itself, because the bank is not really interested in the kind of disputes between the purchasers and between the sellers and the purchasers. They are interested in the bank guarantee alone. And if there is a valid invocation, then the bank guarantee has to be paid. So in one of the recent cases, again, Union of India versus Nayak Infrastructure, these are all, I think the citations have gone notes below. So these are all 2021-22 cases. So here the purchaser had obtained an injunction from a lower court, but the moment the appellate, there was an appeal filed, the High Court immediately vacated the injunction, stating clearly that the invocation of bank guarantee is an independent and a unique, it's a unique transaction in itself. You don't really have to link it to this and get into establishments of breaches and other things. There can be injunctions, but the invocation of bank guarantee is generally not interfered with in case it's an unconditional bank guarantee. Now we'll move on to, again, when we speak of bank guarantee, it's of course a very conscious kind of a clause wherein you need to determine which bank you're going to use. The format is there. So bank guarantees are always thought through. The amount is debated, and you can always think about it, the amount, and then sign into a bank guarantee. Then there are warranties. So warranties, representations, these are very important in a document. And what we need to understand is that a representation of warranty is always drafted specifically. There are always you'll see some kind of representations and warranties in all documents wherein each party says that, yes, I can sign this document, I can do my obligations, whatever I'm covering to. But if you go to the first slide, when we had spoken initially about understanding the perspective. So when you understand the perspective of the contract, then you customize the representations to make sure that you have the right representations. Like there are few examples that there are multiple examples that we can give, but one simple example that we can look at is somebody is giving some products to another. So A represents that A shall provide products in a timely manner to B. When I say that as a representation and when I draft it in a different manner, I say A represents that A shall provide new, original and non-infringing products to B within, you have to take the client's inputs within say 7 days, 10 days on receipt of PO, time being essence of contract. So the entire weight of representation changes when you apply yourself to it. When we simply say that, okay, I want the products. It's like, sometimes it's very important, it's, even if a contract is a piece of paper, ultimately it is being handled by parties, by persons. And we all know, we are all mature adults in our interactions, that every time an expectation has to be set out very clearly. Even if you are dealing with a child, or whether you're dealing with your colleagues, whether you're dealing with your teachers, whether you're dealing with your bosses, or whether you're dealing with with the people with whom you do business with them, you need to set out your expectations very clearly. Unless and until it is set out very clearly, you can expect some misunderstanding here and there. So often it is seen that the parties do not, there's an interesting judgment which I can share on this. I don't have the citation here with me, but it related to the kind of products which was supposed to be given by one party to another. It was related to coal. And the purchaser said that I was going to give them unprocessed coal. But the other part, the customer said that, what unprocessed? As a customer, how am I going to process it? You have to do the processing and give me. And then they litigated, and the court said that, yes, it is. They litigated for almost 8 to 10 years on this, what was the quality of the coal which was supposed to be given, whether it was processed or unprocessed. Now, when they litigated on this, the court put itself, then the court is going to interpret, they're going to think of the contract, they're going to look at it, what was the intention of the parties when they signed the contract. And, it's going to take a lot of time. To avoid all that, make your representations very, very clear. If you want something in a particular manner, you want something within a particular timeline, we need to state that in the contract. The more professional or the easier our contracts are for the other party to understand and read, the easier it is to enforce them. Because if it says very clearly that I want new product, I was really not looking at an old product from you, or I was not looking at a used product. People sell used products also. There is a whole platform in today's world wherein, it's only for used products. We really need to understand what is it that we are looking at it. Now, if a contract requires the vendors to perform something, but you don't put any timeline, then it's very difficult to establish anything, So you need to draft it very clearly, very categorically, very clearly, to understand very cogently, to see, what is it. Even a child, if they look at the contract, or sorry, not a child maybe, but anybody who looks at a contract with a non-legal background can also understand what is meant by it. Now, again, for representations and warranties, we need to remember that every contract is unique, every agreement is unique. Explicit representations and warranties are to be identified specifically by the party. Similarly, as much as you identify a representation and warranty, if you're a vendor, you can also look at some specific disclaimers. This helps to ensure that there is no confusion, that if a contract is entered into, the parties are not confused that what have I agreed to. If there are SLAs, SLA is a service level agreement, or if there is a timely discharge of obligations which is expected. Say, when you're looking at software contracts, there's a particular downtime which is agreed. You have certain maintenance hours. You have certain time when the services are all going to be available. Like today, we live in a world where everybody, if it's a Wi-Fi services, I want it to be available all the time, whether it's day or whether it's night. I am not going to allow any time when it's not available to me. I must remember that, the expectations are set out very clearly in the contract. And here there is an important point that I would like to stress upon. And that every kind of a contract, when I'm seeing, it's established with through the document itself. I'm not required to go into some kind of a correspondence, some email somewhere, because the moment the contract is signed, the contract holds the binding value. You will have that boilerplate clause, which says that the entire agreement, that this is the agreement which is going to prevail, not some kind of a proposed came to you, some fancy proposal which came to you as a customer, agreed, some say a business requirement or some kind of an email which should come at some other point in time. Your agreement is important. So that's why the agreement needs to contain all kind of representations and warranties. Sometimes, yes, it does happen that in big contracts, we cannot list everything in that document, but we can always provide a name. We can always provide a schedule. We can always include a reference. So we can always say that, okay, this is the kind of the contract and this is governed by these specifications which are listed here in this document. So, but setting it out very clearly is important, because unless and until it is set out very clearly, you cannot establish breach. There is no way we can do that. Now, there's another interesting case which is currently before the Supreme Court. It is being reconsidered. It's about the group company doctrine. So I think most of you may be aware of it, that in today's world, there are a lot of companies which, not in today's world, since many years, people operate through their own affiliates, through their own sister concerns. So I have a group of companies, and Chloro Controls was the judgment which had come somewhere in 2007 or so, and which said very clearly that in case of multiple agreements between entities, there is, if one entity has signed for a dispute resolution as arbitration, even if other entities have not signed, but the transaction is one whole unique transaction, or it's one whole transaction of which there's one supply contract, there's one services agreement, there's one maintenance agreement, there is one another document of letter which is signed between them, and each of them is signed by a different party or other different entity of the same group. In such cases, there is a group doctrine which is applicable, and arbitration clause, if signed in the mother agreement, is applicable to all. So in these cases, this was the judgment under Chloro Control. So now this is being reconsidered under Cox and Kings. So here, Cox and Kings was the customer or the purchaser, and they were taking some services from SAP. When they were taking certain services from SAP, the document was signed between SAP India and Cox. So SAP GmbH, which is a German entity, they had not signed the document. They were not an executed. They were not a signatory to the document. But the customer wanted to enforce, because there were certain customizations which were needed on the software, for which definitely the involvement of the parent company was needed. Now, if you look at certain software companies, the ownership of the IPR of the software is sometimes kept with the parent entity, or sometimes it's mutually discussed that, okay, my IPR remains with my US entity, my IPR remains with them, I'm a licensee, but I can sell you. So in this case, when the customer said that, no, we want the German entity to be a party to this litigation, and there is an arbitration clause, but the German entity was not a signatory to it. But in spite of them not being a signatory, they wanted to apply the Chloro Controls judgment, and now this is being reconsidered, and it is before the Supreme Court. So the judgment is expected soon on this. So to cut the long point short, when you expect some kind of representations in a group contract, like you are dealing with the Indian entity, but you actually want the US entity to give you certain not US entity or any other entity which is based in some other country to give you the actual representations, making them signatories to the contract can also help, or at least thinking about it, whether we really want to make them or whether we don't want to make them, and we are aware that because we are signing the document with the Indian entity is going to be the provider in that. So representations and warranties are again very important. They need to be spelled out very clearly in the document itself. Now, when we look at another remedy which can be incorporated in the document, which can be refund, repair, or sometimes exchange. So we are all aware of it. We order products online all the time. So when refund is a common remedy which is incorporated everywhere, so the extent of refund, that can be, whether it is pro rata, whether it is complete, how is it invoked, can I set it off, can I use it from some other document? So all these kind of questions should be answered very clearly in the refund clause, which is there in your document. Because sometimes if there is a one-liner clause that yes, the customer is entitled to a refund, but how can he set it off? And as a customer, what I'm going to do is I'm going to set it off. I may not want to pay. So refund it's a common remedy, but at the same time, common sense is not very common. So you need to put it very clearly. What is it that you're going to refund? Suppose I have paid for the whole year and I want to terminate the contract in the 6th month for no fault of yours, but I just want, I want to shift my service provider. I'm shifting locations. I'm shifting from Bombay to say London. So I want to change. So I want to stop the services. So what the customer can say, oh, you said refund, so you give me complete refund. But the service provider will definitely say that the services have been utilized for 6 months. So I cannot definitely give you a complete refund. You have utilized my services for part. So at least that pro rata needs to be incorporated here. And we must remember that when it comes to a contract, it's very easy to, interpret it both ways once it's signed if it's not clear. So clarity is very important in a contract. There needs to be certain obligations which are included, but do it properly. If you look at a repair obligation, when is a repair possible? Is it possible because for all sort of reasons, or for only when something, was attributable to the vendor really? So these kind of remedies, if they're there in the contract and if they're clearly defined, it will help. Another important remedy that we can look at is insurance. Insurance is something which really helps, because it's an important obligation to remedy any possible any possible damage or any possible errors. Now, what are the nature of the agreements? Depending on that, you can get all kind of insurances. There are multiple insurances available in today's world. You can go for error and omissions, you can go for fidelity, you can go for your key management personal insurances, you can go for the standard insurances which are required. So purchaser can, also require that, yes, you please take these insurances so that if something goes wrong tomorrow, we have an insurance remedy available to us. Sometimes purchasers also insist that they should be named as co-insurers or co-beneficiaries, or somebody who can always take the benefit of the insurance as well. So this, of course, it depends on a case-to-case basis. It depends on the negotiations amongst the parties. There is nothing which is a standard here. There is nothing which has to be implemented across all the contracts really. So we need to see what is important, and then you give it the shape of the clause really as per the whatever is implementable. Now, damages. This is a very important clause again, which speaks about, what kind of damages can be levied on the other party. Damages are defined under Section 73 of the Contract Act in India. And here, when we look at damages, we could say damages for defaults, for delays, for breaches, for, some kind of compensation. But we must always remember that the law itself states, and as conscious contracts, we should also see that the contract, it's not something which is a remote consequence of it. It's a compensation, right, for something which is an actual damage which is suffered. It's not something which you want to claim for something which is remote and which is consequential. So having very huge damages clause is not going to help. You need to understand what is it that you can make them liable for. And ultimately, an entity is, barring a few critical contracts on an organization, there are general contracts which are, which come and go, wherein we have vendors, they come and go. So for all those kind of generic contracts, we don't need like a huge liabilities, and we don't need huge kind of, 1.5 pages damage clause. So keep it limited to what is, understand the perspective of the parties, and then make them liable for those specific damages. Now here, there's a small example that we can look at, that if A promises to deliver certain specific equipment to B, which is essential for completion of the project. Now, relying upon A's promise, B has committed to the ultimate customer, which is C, as we saw in those huge contracts. There is a subcontractor, there is a contractor, then there's a principal contractor, there might be the ultimate client. So in these cases, what happens is that there might be a small contractor and he's not able to meet his commitment, but there was no back-to-back arrangement for him. Like B was not aware in this case that there was any further commitment. So if A fails to deliver the project and he's not able to meet his commitment, he cannot be made liable for everything. He cannot be made liable for something which C imposes on them, who's the ultimate customer. He's responsible for his share, and that's all. Something which he was not aware, something which is too remote, something which is absolutely, very, very way away, that's really not imposable on them. Now, we've seen these 7 clauses of the contracts. We looked at indemnity, we looked at risk purchase, we looked at representations, warranties, refunds, insurances, damages. So while all of these, elaborate clauses are there in a document, I would like to, there are 2 more slides which we have on this, which is on the procedural safeguards. That we must remember, there's a very recent case of Padia Timber Chemical Company Private Limited versus the Board of Trustees of Visakhapatnam. So here what happened was, there was a risk purchase clause which was incorporated in the document, and the Board of Trustees of Visakhapatnam Port Trust, they were the purchasers. They had given a contract to this Padia Timber Company in 1990. When they gave this contract, they had included a risk purchase clause in the tender. So, but the vendor, he never really gave us complete acceptance. There was a lot of debate on the site of inspection, since it was for a huge equipment. Equipment. They wanted the inspection to happen at the factory premises or at the office premises of the vendor, whereas the board said that you need to come and do the inspection at our site. So there was some kind of disagreement on this point. It was a conditional acceptance by the vendor. When it's a conditional acceptance, the contract was never concluded. And that was the vendor's stand. They litigated for almost 23 years. After 23 years, the Supreme Court said that, oh, the contract was never concluded. There was a conditional acceptance. You had never signed a proper document. And if you want to establish the contract through the exchange of correspondences, it's very difficult to establish. So in spite of you having your risk purchase clause, indemnity clause, and A, B, C, D, big remedies that you have there, you cannot enforce it because the procedural safeguard itself is not met. The parties have never executed. There is no contract to rely on. So you must remember that while you draft these lengthy requirements, the clients are appropriately educated on how to execute the contract, or that do it properly. It needs to be done. There needs to be a signature, or if you want to establish something through the correspondences, there is a clear acceptance from their side. So this is very important to ensure. Now, if you look at as a closing note, I would like to leave you with some best practices, which I think will help you always when you look at any kind of contract drafting or any kind of contract review also. That maintaining a balance of rights and obligations is very important. It's not something wherein, we have one side is just too powerful. Typically, any kind of an unconscionable bargain, unconscionable is not defined in the Contract Act, but the doctrine has been recognized in some kind of in the judgments also. Typically, Central Inland Water Works versus Brujanath Ganguly is a very important judgment in this context. It was an employer-employee litigation, and typically in employer-employee kind of an agreement, we see that the employees have no rights. Employers generally tend to make it very one-sided, and for natural reasons, because it's a contract which is executed with everybody. They may have 10,000 employees, and we are not sure about the integrity and about the genuinity of each employee who enters the organization when that employee enters. Of course, the employee, they're genuine, very good. So the legal department is going to take every pain to make sure that, it's very well done. But overtly unconscionable, or, something which is too tilted, something which, say bars the other side from doing something which is so naturally, which is available to them under the law. Those kind of documents, those kind of clauses may fail the test of enforceability at the court again. We have to again look at every transaction differently, every case uniquely. So that's very important that we maintain a balance of rights and obligations. It's always something which you want to see, which you want to enforce properly. Then remedies are to be without prejudice to each other. So as we said that, normally for damages or for risk purchase clause, typically people like to invoke everything at the same time. Okay, let's now corner and let's take everything. So you need to have a contract properly drafted to that extent to ensure that, if you invoke one, or, at least the contract is understood properly. Like how it happens sometimes in today's world is contract is drafted by another, vetted by another, finalized by somebody else. And then by the time the enforcement comes after 4 or 5 years or 2 years, there's a different legal team altogether. So the remedies are properly drafted. Sometimes they are drafted without prejudice to each other. So you can invoke one, maybe you can invoke 2 or 3 at the same time. Or if you want to invoke everything at the same time, then whether the circumstances really warrant that kind of an action. So all these kind of things need to be remembered. And, if you try to maintain a balance, I feel that the contract will be properly enforced and hopefully not reach a state of litigation. So with that, I think I would like to end my session.
The time can only be a factor to invoke the risk purchase.
Time. Okay. No. You can draft it to suit your requirements. See, typically risk purchase clause, there is an urgency there. Because risk purchase clause, you're not going to invoke it every point in time. Like, even we do it, but you draft it appropriately. It's a remedy which is in your hands. It's something you customize it to yourself. You can make it even for defective products. If they may have been received on time, but the product is so horrible that you cannot use it in any manner whatsoever. So you can use even extend it to defective products.
Okay.
But you need to write it clearly.
Okay. What amount of bank guarantee is to be given like in a contract? Like if it is a government contract or a metro contract, if it is like a 1,000 crore project. So for a crore project, how much of a bank guarantee should be given, like to be expected from the parties?
See, this is a very case-specific question, Shreya. See, what happens is, and typically I'll tell you, you don't have a say there. Because if it's a government contract and if it's a 1,000 crore contract, they will expect an advance bank guarantee. They will expect a performance bank guarantee. They might also expect something to be kept with them as a defect liability. So they might expect, it really depends, we cannot really give you a figure, but the whole project amount is not going to be taken from you, of course. But some percentage, depending upon the sector and depending upon the criticality of the project. Like I think when they were doing that Statue of Unity for Sardar Vallabhbhai Patel at Gujarat, I think there was a huge bank guarantee which was there. I think I read it somewhere.
Okay. There should be, you said like there should be a balance in a contract, right?
Hmm.
So in like a lot of contracts that I've seen, only the party who is going with a government kind of an entity, so
Hmm.
they have points related only to them, and it is
Yeah.
acceptable by the vendor or the contractor.
So you're saying that a government contract typically is one-sided. Is that what you
Yes,
want to say, Shreyas?
yes.
Yeah, you're absolutely right. I agree with you on that. But the last case that we saw, which is of that Pardia Chemicals versus the Vishakhapatnam, that board trust case, that was also a government contract only. And I will post, I think, the link also of that judgment. That's an absolute interesting judgment to read. They said that it was very one-sided. They had like a huge risk purchase clause. They had like a huge indemnity clause. And not just the dispute there was on the site of inspection. The vendor said that, I cannot carry the equipment to your office for inspection and then you tell me default. I take it back to my factory, rectify it and get it back to you. So it was a very valid requirement that he had, and he had never accepted the terms. But in spite of him not accepting the terms, the board gave him a PO and they enforced a risk purchase clause and then they demanded money from him. So he had to litigate for 23 years to get it set aside, which is of course not a very great thing. But typically when you see a government contract which is absolutely one-sided and you're advising on such a contract, what I would suggest is you must always raise all the flags. You must raise all the flags so that your client is conscious that yes, all of this is there, and make him aware that, okay, even if it is one-sided, to enforce it is one-sided, or to enforce that, it is not prior right on your part, you're going to spend a lot of money. So you be sure when you enter into a government contract whether you are going to be able to give those services or no. And typically in RFQs, there is a procedure which is there which allows the vendor to go for a meeting. It's called a pre-bid meeting, wherein
Yes.
you can go and so I think it's after the deposit of the EMD. So you can go for during the pre-bid meeting and make it very clear. Like, a lot of banks these days, we have advised some kind of software contracts wherein bank is trying to automate its own system. They want to purchase some kind of licenses or some kind of software for their whole system. So it's a different contract. I mean, when you're taking services for lighting your bank, they suppose Bank of Baroda, they want a contractor for lighting, or they want a contractor for their account management system. So it's a very different requirement. And typically a government contract, you will see it why it is one-sided is because sometimes it's not customized to suit your needs. So there'll be irrelevant stuff, there'll be inapplicable stuff. So make sure that you record at least you record it to your client that, there are these 15 or 20 clauses which are not balanced and which are not in your favor. So you decide whether you want to take the risk or take a conscious call on it. Your endeavor to make it a balanced contract should always be there. If it happens, okay. Even if it does not happen, you should raise your concerns to your client, in my view, because you may not always be able to, bulldoze your ways through a government contract. That's also there.
Yes, ma'am. That is all I had to
Thank
say.
you. Thank you,
Thank you,
Shreyas.
ma'am. Thank you.
Ma'am, you gave the two important clauses like indemnity and insurance. Like according to me, like insurance is also a kind of indemnity, where the one party indemnify for the unforeseen event. So how they are different?
All right. So Tina, these are two different clauses. Insurance is something where, it is it's like a medical insurance, I mean, if you have a medical insurance, you are definitely going to get the money if you fall within the clauses of that insurance. But indemnity is something when, you have to enforce it. There is no fund there. There is no third party who's going to give you the money. In insurance, there is an insurance provider, no? So he is going to give you the money. Insurance is a stronger clause in that respect, provided, the kind of breach or the kind of recovery that you want to make falls within that purview. But indemnity is a right. Now, when I have a right as an indemnity holder, I can go and enforce it in a court, but I have to enforce it. And if you look at the current Indian judicial system, it's going to take a while. I will go to the court. I will show that I have a letter of indemnity. Then what they will do? They will issue the notice to the other side. Then they will, once they issue the notice to the other side, they will come. The other side will come. Then they will contest. There was no breach. Why she's asking for an indemnity? They will say there was no delay. Why there's an indemnity? So all that contesting will happen. And then if the judgment goes in your favor, you will be able to reap the benefits of that indemnity. Yes.
Okay,
tell me.
suppose there is a company who committed a default and the bank guarantee is revoked. So in that case, they can proceed against the company again if they recover the whole amount from the guarantor?
Borrower, you're talking about a loan document, loan transaction, credit facility.
Yes.
Yeah, so if they recover the whole amount along with the interest from the guarantor, then I think the guarantor will go after the borrower, no?
Okay, so उनके पास जिसने लोन लिया उनके पास कोई राइट नहीं होगा टू प्रोसीड अगेंस्ट द प्रिंसिपल डेटर, राइट?
नहीं, देखिए, जैसे अब अगर एक बैंक है, सपोज आप एक बैंक लीजिए, आईसीआईसीआई बैंक है, आईसीआईसीआई बैंक ने लोन दिया है ए को एंड गारंटर इज बी. So as bank, I am entitled to say 10 lakh of rupees along with every possible expense that I can take, that interest is there, penal interest is there, damage is there, cost is there, litigation cost is there. मैंने सब कुछ वो गारंटर से ले लिया है, मेरे पास तो पैसे आ गए ना बैंक करके. So I am not again going to double jeopardize and again recover the same amount from the borrower, ना. उस केस में क्या होगा, जो गारंटर है ना, वो गारंटर borrower के पीछे पड़ेगा.
Okay. Thank you, ma'am.
So it's not like the borrower will go scot-free because, the guarantor has paid.
Thank you.
Yeah, if a time limit has been stipulated, categorically the contract should the industry practice construed. This is a very tricky question, Vidyanand. So see, what happens is, it's a very tricky situation. When you don't stipulate something into the contract and when you want to enforce some kind of an industry-wide practice, first of all, nobody will agree on what is the industry-wide practice. See, it's very difficult to define. Now, typically you'll see in a contract where people will say that you have to give me products as per generally accepted industry standards. Somebody will say as per generally accepted industry standards. Somebody will say as per best industry practices. So these are all, I always feel that they are not absolutely, they're not terms which are always easily enforceable, because there is a wide amount of disagreement, and especially so when parties are litigating. Even if they know, they are not going to agree. So there will be some amount of disagreement, and plus industry-wide practices also differ region-wise. Like, there is a different industry practice for a particular industry. Say in garment sector, there is a particular practice in Bombay. There is a different practice in, say Kolkata or some region which has some kind of a phenomena. Like, if you say that delivery of products, so markets are closed in every industry, in every region differently. Or if you look at, it's very difficult to establish through this. So it's always better that you frame it specifically in your contract. You don't rely on anything which is likely to be generally applicable. And even if it is going to be generally applicable, it's going to be a very long litigation to enforce in the court. You have to establish what's the practice. You have to say that parties actually thought of this. So I would find it a little odd in that case.
As a routine, do lawyers adopt an approach while drafting contracts? Must be an authoritative approach or a pragmatic approach.
Okay, so this depends on the client again, or depending on whom you are for. See, as lawyers, you're going to meet all kinds of clients. So when you draft the document, it's not really your document. We must remember that it's the client's document. So when it's going to the other party, it must signify the position of that client in the market in which it operates. So there are different kinds. If you're drafting a contract for a portal like Amazon, your approach is going to be different. If you're going to draft a contract for a startup, your approach is going to be a little different, of course. Because, it's we must remember as lawyers that we don't really get attached to the document as our documents really. See, of course, it's drafted by you. So you are going to feel some amount of, okay, I've drafted it, but it ultimately represents your client's stance in the market. So you should see the client whom you are going to draft it for and then make it according to them. That's what I do. I generally don't want to use the same approach for everybody.
Okay, that's great.
Maintaining the balance of rights and obligations. Typically, when you look at contracts, say, for example, warehousing contracts with multinational companies, they have one-sided contract on take it or leave it basis. Okay.
Yeah.
So if I sign those contracts and I see that it is one-sided, then do I have any remedy in the court of law? In that case, the court will say that you have accepted all the terms and conditions. So now why are you coming to this court saying that it is a one-sided agreement? That is my first question regarding maintaining balance of rights and obligation. And second thing is regarding the cross-border transaction where different jurisdictions are involved. Say, for example, if the contract says that the contract will be governed by English law in Singapore. So how will English law in Singapore will be adjusted? Whether it will be English law as per England Civil Procedure Code in Singapore or English law as per Singapore Civil Procedure Code? Those are my two questions, ma'am.
So say, let's see, look at the first contract, first query first. So yeah, if you have already signed a contract, see, then your position is extremely weak. If you see a contract with an MNC, which is absolutely one-sided, but you're in need of business and you want to sign the contract, then it's a conscious risk that you have stepped into and you have actually signed that contract. And see, this is typically seen in many kind of cases of bank borrowers also. All borrowers want to generally take that defense that, I had not seen the document. I don't even know the English language in which it is written, I don't know what I have signed. So this kind of a defense is very difficult to prove in a court of law. When we talk about maintaining rights and obligations, it's not the court's job to maintain rights and obligations in a private contract between the parties. See, it's your job, as you have to be a little zealous about your rights. And yes, I do appreciate that a lot of MNCs have absolutely one-sided documents. Sometimes they're not relevant also. Like you are doing some, that's what I said when I spoke about indemnity, that somebody who's giving courier services or, some other services, they want an IP infringement indemnity in that case. So in that case, it's important to pursue that negotiation process for a while, because I think business experience will also show you that, in case once you sign the document, the attitude of the parties are also very different. So they might come up with their own reasons that, oh no, this is a form, this is a format, I'm not going to change anything. But you need to pursue with it a little bit more. You need to make your point clear to them that this is not applicable or this is not really relevant also to my case. I am giving you warehouse services. You have written things about, IP infringement. You have written things about software also in that. You have written things maybe about, say, data privacy in that. So how is all of this relevant? You need to spend some time on it, maybe with somebody who can help you guide the contract, who can also explain it to the other side. It's a lengthy process. I am not saying it's a piece of cake or it's, it's a cakewalk to just, okay, go and explain it to some government entity or to some MNC that, no, I don't want to sign this document. It's difficult, but it is more difficult to say something at a later date that what's the difference that you're going to have? You've already signed the document. So it's, you have to take the contract negotiation process route. That would be my response to your first query. Then, do you want to say anything on that?
No, ma'am. I mean, because it was just, I come across some documents where it is absolutely one-sided.
No, then you need to push it back. And see, we need to push it back and we need to raise our voice. I mean, not voice as in literally voice, but yeah, I mean, if something is not relevant, it's a contract. So, it's a valuable piece of paper. It's not something where, and as connecting it to your second query, if it has a cross-border reference, if it is enforceable in some court in London. So this is going to be extremely expensive affair. And this is becoming more and more so because, the world is becoming more connected than ever before. We are dealing with parties. Of course, the business is good. The money is also good. But at the same time, the liabilities are also high because the expectations are very high. So we need to make a conscious call, take a conscious call there and make sure that, the contract is properly done. Now, when you look at a contract which says that, it is applicable, say the law of England will apply, but they provide the venue of the dispute resolution as Singapore. So there is a distinction between venue and seat. And there is a distinction between substantive law and the procedural law. But what happens is that, procedural law is very different. Like, the procedure code, which is there, which might be applicable as per the law of the land. But the substantive law, which says that what kind of damages you are entitled to. Say, we have the Indian Contract Act. So our Contract Act provides that remote consequential losses or damages should not be looked into. So that's the substantive law. So substantive law, maybe the parties intend that they want to apply the English substantial law, but the procedural law of Singapore is applicable. Or if they have provided for an arbitration under a particular tribunal, like they have provided for arbitration under SICA, they may say that the procedural rules of that tribunal will be applicable to them.
Thank you, ma'am. Thank you very much.
Thank you, sir. And thank you, Aarti, once again for addressing the query and again for the wonderful webinar.
Thank you. Thank you so much, Malvika. Thank you, everybody.